So my name is Brian Gray. I'm on the faculty at UC Hastings Law School in San Francisco, and I'm also one of the co-authors of the report. And this panel will be talking about the legal issues associated with Propositions 218 and 26, which, as Ellen described them briefly this morning, were enacted by the voters as constitutional amendments in 1996 and 2010, respectively. And what we're going to look at is the effects of these two laws on water rates, water rate making, regulation of groundwater withdrawals, stormwater discharge, flood discharges, other types of regulatory fees. And we're also going to talk about what effects those laws, as well as the court's interpretations of them, have had on water supply, water resources management more generally, as well as water stewardship. Before we begin, I just wanted to just say briefly, give a brief tribute to my friend Joe Sachs, whom many of you knew, who passed away last month. Joe taught at the University of Colorado and then the University of Michigan, and he concluded his career at UC Berkeley. The New York Times obituary for him is truly awe-inspiring, and I would recommend that you read it. Joe was the intellectual foundation of the modern environmental era. He grappled, I think, more incisively with the question of the relationship between private property and environmental regulation, the relationship between private property rights and the public interest in how our lands and waters and resources are used, far more than anyone else that I know, including the justices on the Supreme Court. Joe also brought the public trust doctrine, this ancient doctrine from Roman and English common law, into the modern era, and laid the foundation for the Mono Lake decision by the California Supreme Court. Joe also, when he arrived in California and taught at Berkeley, immersed himself in California water. And I think Joe really saw more clearly and more deeply than anyone else. And I think that we haven't even begun to imagine yet how much we're going to miss him. So I just wanted to thank you. Thank you. He was also just a really good guy, too, I will say, and I miss him a lot. So I want to introduce our panelists just very briefly, because we're 10 minutes late on time. So to my left is Lauren Kay. Lauren is president of the California Foundation for Commerce and Education, and he has dedicated his career to developing and analyzing and implementing public policy issues in California, with a special emphasis on improving the state's business and economic climate. He's also a gubernatorial appointee to the Little Hoover Commission. Sean Korn is an associate vice president and the Northwest lead for HDR Engineering's utility rates and finance group, and he provides financial planning, cost-benefit analysis, funding analysis, and economic review to a variety of different types of agencies which are trying to accomplish both their programmatic and revenue needs, but also comply with Propositions 218 and 26. Kelly Salt is a partner at Best & Krieger in their public finance practice group in San Diego. Kelly gives advice to, again, a large variety of agencies on bonding and financing issues. She's also authored and edited guides to Propositions 218 and 26 for the League of California Cities, the Association of California Water Agencies, and the California Special Districts Association. And then finally, the far end of our panel here, Greg Weber is a professor at the University of the Pacific's McGeorge School of Law, where he specializes in alternative dispute resolution as well as water resources. Greg will be retiring from McGeorge at the end of this semester and will be moving to a new position as executive director of the California Urban Water Conservation Council. And Greg asked me just to point out that the views that he expresses today are not necessarily those of the council. I also wanted to mention that Greg's most recent publication is called A New Water Accounting, which is a detailed, and I will say, highly readable analysis of Proposition 218 that I would commend to all of you, and it was just published at UC Berkeley's Ecology Law Quarterly. So with that, I want to start actually with Greg and ask Greg to give a brief overview of Propositions 218 and 26, and then I'm just going to ask Lauren to follow that up with a little discussion about the purposes of those laws. So Greg, we'll start with you.
Brief, one page. Let's see if I can stick to it. Am I mic'd okay? Yes? No?
You'll have to play the professor and just talk very loudly.
I'm happy to project. That sounds better. Just have to think on my feet. There we go. Thank you. So let's talk about 218 first and then 26. That's the order that they were adopted by the electorate here. So both of these propositions, which, as you've heard already, have enacted constitutional provisions, both of them have substantive and procedural sides. So if we start on 218, we'll talk about the substance. It's usually referred to that there are 5 substantive points. I'm going to call it 5.5 because there's one that's kind of a wobbler. But let's start first with the limit. For property-related services, and that's just what I'm going to focus on here. It does a lot of other things as well, but the closest connection with water, or the one I've done the most work on, is for property-related services. So the limit is that revenues may not exceed the funds required to provide those services. So first there's a substantive revenue limit. Then secondly, there's a purpose limitation. Collected funds can only be used for the purposes for which they are collected. So limits, purpose. Third one is perhaps the one that bugs me the most, and that's the proportionality requirement. It says that the amount of the fees may not exceed the proportional cost of providing service to the parcel. And it seems to suggest that the water agencies are going to have a parcel-by-parcel rate structure, which is just completely absurd. And recent court opinions seem to be moving away from that. Fourth point, availability. The service must be immediately available to the customer. You can't collect in advance for future services. And then lastly, the services must be special. That is, there can't just be fees imposed for general government services that are substantially available to everybody and not just to property owners. So the wobbler here in between substance and procedure is the burden of proof. The traditional burden of proof in rate-setting cases was on the challenger to prove that the rates were unreasonable, inequitable, disproportionate. Prop 218 and also 26 reverses that traditional presumption and imposes it on the agency and not on the challengers. So those are the 5.5 points of substance. 2 points on procedure. First, it requires for the water rates, public hearings are required, and a written protest by a majority of owners of the parcel can override the proposed rate structure. And then for fees other than water, sewer, or refuse collection, there has to be an actual public vote. And that can either be by a majority of the affected landowners, again, these are property-related services, or it can be 2/3 of the registered voters within the affected area. So that's Prop 218, both the substance and the procedure. Moving on quickly to Prop 26, I'm going to do it in reverse order. I'll talk procedure first. The main procedural change of note that Prop 26 added, at least from my perspective, is that it imposed a 2/3 vote requirement on the legislature if any individual ends up paying a higher tax, even if the overall revenue bill is neutral. It doesn't raise more revenue, but just adjusts the burden. So Prop 26 changed that, and now any individual affected by a state revenue bill must be passed by 2/3 of the legislature. Substance, there's basically one big piece, and that is it redefines everything except a few specified items as a tax. So in effect, you have to look for an exception, or otherwise any fee or charge, or exaction is probably the better term, is going to be considered a tax, and it's going to have to meet whatever burdens are necessary for taxes. So the exemptions are charges that are those to pay for the reasonable costs of providing a special benefit, service, or product, for running regulatory or permitting conduct. Third, property development fees, and then those Prop 218 assessments and property-related fees that I talked about earlier. Again, the burden is on the agency to justify that it is not a tax, that it fits within the exemption. Very briefly, on the appellate case law, we now know a good bit about 218. We don't know much about 26. So as far as 218 and water, what the appellate courts have started telling us is that, yes, indeed, 218 does apply to the delivery of water to existing connections. That was actually in some doubt for a while. We also know that it covers groundwater augmentation fees, and we're going to talk more about that later on. We know that the costs that can be passed on include debt servicing and an agency's general expenses. We know that there are 2 cases on proportionality, one of which I'm not going to talk about because it doesn't tell much about the law. It just tells lawyers, agencies, and rate-setting consultants to do a better explanatory and documentation job. But the other one, the more recent case, made some nice changes or made some nice statements and included that apportionment does not lend itself to precise calculation and allows agencies some substantial leeway in grouping similarly situated ratepayers. So not parcel by parcel, but similarly situated ratepayers, and charging each group an appropriate rate. So that, I think, encouraged a lot of people. And then lastly, we know that as far as the limitation on charges for future services, which are banned under 218, the same recent case adopted a fairly broad notion that current water service includes the planning and preparation to continue that water service in the future, such as by the addition of new facilities. So I think that was very encouraging as well.
Great. That's a very quick summary that I wouldn't have thought possible, and I thought very clear as well. So, Lauren, why did the voters enact these laws, and what do you think their important purposes are?
Okay. I can't hear myself. Is my mic on? Okay, great. Thank you. Thank you, Brian, and thank you, Ellen and PPIC for having me here. I'm probably going to perhaps bring a little more disagreement to some of these issues. Maybe not as much as Lester, but we'll see. We'll see. So, just historically, and I won't talk legally, I'll talk more politically. Historically, this is all, as Ellen and her team pointed out, this goes back 35 years to Prop 13. And Prop 13, for those of you who may have been of voting age, the few of you in this room who may have been of voting age at that time, that was a very important moment in time for California, because the voters basically said, we want more say on what is going on, particularly at local government, because we have felt abused in terms of our property taxes going up. And there were a lot of really scary things that were happening at the time. There were reforms that were tried in the late 60s and the early 70s, and they never happened. The legislature completely dropped the ball in the mid-70s on property tax reform, and the people just had enough. And they took what was probably an insufficiently vetted initiative, but it's what was on the table at the time. They took it, they passed it by a 2-to-1 vote, and the people have been very, very satisfied with it ever since. Now, but what happened since Prop 13, and certainly in the 5 or 10 years after Prop 13, is the local government and the courts were trying to deal with this massive change, not just in the actual fiscal situation where property taxes were cut in about half and went on a much slower trajectory than they were before. But there was a lot of changes in the, as you heard discussed, the adoption requirements and such. And so the courts made a bunch of decisions on taxes and fees, and local government went, to use an inapt metaphor, water, seeks the shortest path to the sea, and local governments sought the easiest way to raise revenues. And so they went to creative uses of new fees and of benefit assessments. The courts, through actually both the Rosebird Court and the Malcolm Lucas Court, were fairly generous in their approval of these tactics by local government. First, in the main decisions, and the lawyers here need to keep me honest on this, but there was the Farrell decision in 1982, which basically created the differentiation between a general tax and a special tax. And then there were some benefit assessment cases later on. I think there was Knox v. Orland, which basically gave local governments fairly broad powers to define what is a benefit when they're putting in a benefit assessment. And these decisions, the use of them, the implementation of them, caused a backlash again among taxpayers, and it brought forth Prop 218, which did not eliminate the use of benefit assessments or fees or taxes. It put these guardrails on them, as were discussed. Changed the burden of proof, but it didn't, unlike Prop 13, which basically took the property tax for operations off the table for any increase. It still left all of these mechanisms in place. Fast forward to about 91 or 2, and the legislature passed a bill which, by a majority vote, which put a fee on the producers of lead products or prior producers of lead products. And it rather than having a very close nexus to the production and use of this product, it basically said that you can use, you would pay this fee even if your product wasn't made anymore, wasn't used anymore, but just because it had an effect on the environment. In this case, either lead paint on the walls or lead from gasoline that was, along the roadsides. I don't know how long lead had been out of gasoline, but a really long time prior to
mid-1970s.
Okay, so say 20 years or 15 to 20 years before. The Supreme Court, this was I think this was the Ron George Court. You guys are going to interrupt me. You lawyers are going to interrupt me if I get something wrong here. Okay. Basically said in the Sinclair decision that was okay, that you could have a fee to mitigate for past harm, even if there was no direct nexus to the production or the use at the current time. This caused a reaction among a broad swath of the business community, and this is where I come into the picture. One thing Brian didn't mention is that my organization is affiliated with the California Chamber of Commerce, and so we have a direct interest in a lot of this stuff. Eventually we sponsored and successfully convinced the voters to support Prop 26, which kind of, the description of it is accurate, but really the spin on it is it did change the burden of proof. But substantively, as a matter of law, it really pretty much made one major change, and that was to narrow the ability of state and local government to, actually it made two major changes. To narrow the ability of state and local government to charge these mitigation fees. And so fees pretty much have to be what you would imagine a fee would be. It has to be closely related to the service or the regulation that's involved. The other change is true on state taxes. You can no longer have netting out tax increases and decreases. If there's a bill that increases taxes and cuts taxes, it's still going to have a 2/3 vote because somebody's getting their tax increased. So that is the genesis of these measures. I hope we have a chance to talk about whether it's a good idea to change these measures, but I'll leave that for a subsequent
Yeah,
question.
and that is certainly on the agenda. So you know, the courts tend to emphasize in their interpretations of both 218 and 26 that they must liberally interpret them to accomplish the purposes of that the voters had of placing limitations on what can be enacted as a fee as opposed to a tax. And that's a point worth emphasizing in your opinion.
Yeah, I suppose. Although, you know, what I'm hearing on Prop 218 is that there have been some pretty good, from your perspective, some pretty good appellate court decisions. And so, you know, I sort of take the liberal interpretation as a term of art. The court's going to do what it's going to do.
I think the fact that the courts are kind of all over the map on this is a good indication of that. Well, let's turn then to Sean and Kelly, and I just wanted to get your experience in working with agencies who have to comply with these laws, and if you could just give us a little description of what have the challenges been, and where you think the success points have been in agencies, you know, finding their way down the proper path to meet the requirements of these laws. So.
Well, let me start by saying that you had asked us to kind of look at what we thought were the advantages and disadvantages, and so I'm going to kind of focus from that perspective. And I have a son right now who is going to college next year, so I'm going to do what he did, or I told him to do, is that, you know, draw a line, put a row of what are the advantages and where are the disadvantages going to this university or that. And so I kind of took that perspective. And so I want to start with, we've all heard it, Prop 218 definitely gave greater transparency and accountability to local governments. And from that perspective, I think it was beneficial. It does force public agencies to look internally at, all right, how do we structure these costs or determine our costs, and then how are we going to allocate those costs to our various customers, whether it be on a class basis or, you know, component basis within the fee structure. I also think that it has resulted in greater public participation, which can also be a negative, because essentially you have a lot of times where you need to go forward with very large capital projects for the benefit of the entire system, but you have often the political element where the public is very fully involved, but maybe a small segment who doesn't really represent the entire community, and that influences the elected officials in their decision making. So I think that has both a positive and a negative. I think it encourages better communication in terms of explaining to the public what it is that these special districts do. I have seen so many times where I've gone to a special district board meeting and there are the board members and maybe 3 people in the audience, 2 of whom are staff members. But you know, when you get to the point where you're starting to do rates, you know, initially at the early Prop 218 hearings, you would see an entire chamber full of folks. Now they're getting to understand the process better. They're getting to understand how their rates are structured, what are the elements of the costs that are involved, and they've become more aware of, you know, rather than just turning on a tap and expecting the water to come down through their pipes, that there are costs associated with that. So I think that's good. I think that it has also improved the economy to the extent it's become the full employment act for rate consultants and for assessment engineers, because they are now very actively involved in developing rates. I think it was far less of an active process for rate consultants before Proposition 218. Now on the disadvantages, and Sean, please, you can jump in at any point too. I think it reduces flexibility in structuring rates. I think some early decisions, in particular in a couple of locations, the San Juan Capistrano case is by way of example, I saw a number of agencies who had tiered rate structures which actually pulled back from doing tiered rate structures and say, nope, we're just going to do a fixed charge, which obviously does not promote water conservation, which is essential to water resource management with the state, which was what we've been talking about all morning. I think the judges, now that they're exercising their independent judgment, it's a little bit of concern because they are not individuals who necessarily have the background to understand the rate structure design and process. And I think I see that in the San Juan Capistrano case in particular, not understanding how you structure rates, how you design them, and what goes into the rate structure design analysis. And so I think to that extent, it's very important for agencies to develop on a better basis their administrative records as they go forward in these actions. There's a cost to it, of course. You have to pay for the cost of mailing all those notices, holding the public hearings, delaying your infrastructure and capital programs in order to meet those deadlines. So there are a number of issues that are associated with the cost of doing it. And for smaller agencies in particular, I think that cost is even larger. Yes, you can pass that on to your customers, but the more frequent process hearings you go through and things of that nature, there is a cost to it. I think, as I said earlier, rate setting has become more political. You just have individuals who want to use as much water as they want to, and others who are hit extremely hard, low income. You no longer have lifeline rates for individuals, and I think that's very troublesome. And it's not going to get cheaper. Water's only going to get more expensive, and for the low-income individuals, that's going to hit them hardest of all. Of course, Prop 218, unfortunately, included the vote of approval requirement for storm water and flood control. And I think that's very troublesome because it obviously has a big impact on cities in particular who are responsible for storm water, yet have limited resources on their general fund now because of Proposition 13, and that's just going to get a smaller and smaller piece of the pie. And then finally, I think you end up with some of the burden of proof changes has resulted in individuals feeling very emboldened to challenge rates now. And again, there's a cost to that. Not necessarily that the rates are incorrect, but they may not like a particular project. We recently experienced that in the city of Davis. Individuals who did not like a particular surface water project that was going forward, they tried to challenge that. It was submitted to the voters do you approve this project? They voted overwhelmingly in favor of it, only to then have the rates challenged, which were going to fund that project. And it's just this sense of entitlement to challenge them in order to espouse a certain position as to how rate structure design is being done. And that truly is the function of the water agency, in my opinion.
Great. Yeah. Sean, what do you have to add to that?
Not a whole lot, actually. We had the same list, quite honestly. But I think there's been, when I went and took a look at this and thought about it in more detail, there was really only a handful of positives or advantages, I think, to it. And I have a whole list, like Kelly did, of disadvantages to it. And I'll come back to the orphan panel earlier this morning. I think it really does hurt the smaller utilities more because it's a lot easier to get a group mobilized in a small town or small utility which only has 1,000 customers to someone who has 3,000, 5,000. And you'll see that in a lot of different places. Is that not on? I don't know if I can turn it on. And so it's easier for them to come back and challenge under the Proposition 218 requirements and to have the council or board not be able to implement those rates. And so I think that's one of the big disadvantages on the small system side that I've seen where, they sit in front of the drugstore or the grocery store with a piece of paper and everybody signs it and you get the whole town signing it. And so it really becomes difficult. One of the other main things that I see as an issue is it really hamstrings the policymakers, your boards or councils, because even if it's a small vocal minority that's out there in front of you, they're really leery of increasing rates. And it's kind of interesting sitting through more of these Prop 218 public hearings than I really want to admit, is that a lot of it comes down to affordability. and people not understanding what the cost of the service really is. And they're not necessarily arguing that the government or the utility is inefficient. They may disagree with some of their practices, but they're typically saying at these hearings, I can't afford this, or there's a segment of the population that can't afford this. And I believe there's a lot of truth to that, but I also believe that we may only be paying $40, $50 a month for water, but we're paying $200 and some for cable each month. And people don't realize it's an issue because they don't see it as an issue. When they turn on the water, it's there. When they flush the toilet, it flushes. You know, stormwater, the one that's effectively been eliminated because any rate increase is eliminated because of Prop 218 in my mind, it's not a problem in the spring unless there's a flood and something happens. Then people worry about it. And so I think that's the biggest disadvantage that I've seen to it, is that the policymakers are very leery from, you know, either being litigated over the issue or not really wanting to take things forward to fund projects because they don't feel like they may have the support of the majority, when in reality, I think they probably do. So.
I just want to know on a personal level, when I turn on my TV on Sunday nights, I want my Game of Thrones there too, just as I want my drinking water. So two of the most controversial interpretations of Proposition 218, Ellen mentioned at the outset, and these come out of the Palmdale and also the Capistrano litigation. The courts have invalidated tiered water pricing, basically on the theory that the agencies in both of those cases didn't precisely enough identify the reasons for the exact tiers that they set, and then how those tiered rates related to the cost of service to individual parcels. And then in the Capistrano case, the court engaged in what we've called in our report molecular accounting, and this again dealt with, the court struck down a recycled water charge that was a charge to all of the customers within the city in order to pay for a recycled water program. The recycled water was physically available only to certain customers. They were primarily agricultural customers. But the city's theory was that using recycled water reduced demand on imported water and was part of their overall water portfolio. And I just throw this out to the whole panel, but are these examples of what Kelly described a few minutes ago as the courts exercising independent judgment without necessarily having a sophisticated or sophisticated enough understanding of contemporary water management?
Well, go ahead, please.
As far as Palmdale goes, I don't know what the court could have done otherwise with the record in front of it. Mm-hmm. And so I don't think there's any independence or lack of understanding. I've looked at the briefs. I haven't looked at the whole trial record. Maybe Kelly has, but the story wasn't there to justify such a huge difference in rates. They're charging agricultural users, which is basically large landscapes in that community. We're charged a proportionally much higher per unit water rate compared to, say, commercial or residential. And maybe that was justified, but it was not in the record.
So if I could just, so yeah. one of the salutary developments of the law, in your opinion, then, would be the courts interpreting Proposition 218 to require greater precision, clarity, and explanation of how they set their rates.
The positive points that Kelly talked about, I think those are positive things. And I just think Capistrano is flat wrong on basic water law. And groundwater augmentation, nobody, when people put water into the ground to save it, which is how Met and many other agencies are going to help get through the next couple of years, they don't have first call on every specific molecule of water. They have a call on a certain amount of water. So the molecular accounting approach, I think there's no basis for it in water law, and to not look at water service as a complete system, I think that's a fundamental misunderstanding.
I agree absolutely, and I think even in the San Juan Capistrano case, the information was there, but part of it was embedded in the rate model, which I think the court perhaps, forgive my brothers and sisters in the black robes, but this is something very different, and you have to have a general understanding of it, and to capture that through a rate model, which Sean can explain, the differences of how you show that, I think is significant, and the information was there in the administrative record. Palmdale, correct. I think there were problems with the administrative record, and there were changes that were done by the board, not at the recommendation of the rate consultant, and I think that was problematic as well. Sean, I mean, you might have some thoughts on that.
Well, I think part of it is that what you said, Kelly, is correct. I think the hard part is being able to explain why you did what you did in a manner that provides that nexus between the cost and the rate or fee that you have. And being able to put that in a report or in writing is a little bit difficult at times, obviously, because there's a lot that goes into that. But I think that's the key part, is being able to document why you incur these costs and why they are important, and provide that nexus between that rate and fee that you have.
We're running a little short on time. I've got about 4 other questions, but one I don't want to let slip by is based on something that Lauren said. We interpret Proposition 26 as requiring that any type of fee that is enacted to deal with legacy pollutants instead be enacted as a special tax. We think the law is very clear. It overturns the Sinclair Paints case that Lauren mentioned a few minutes ago. But we also take the position, which I think is a controversial one, that what it does not do is require that regulatory fees that are designed essentially to internalize externalities prospectively, to charge resource users, dischargers, for the external costs of their actions. We think that can continue to be enacted as a fee rather than as a special tax. And I'd like to get the panel's views on that, but I want to start with Lauren and ask if you agree with that.
Well, if there's an appropriate nexus there, yeah, of course. Okay. You know, it has to be part of a legitimate regulatory program. And so, you know, if you are charging a fee to clean up to clean up a or well, let me back up. If you're charging a fee to prevent to pay for a regulatory program that, among other things, requires charges a fee to help clean up some pollution that is incidental to that industry, which the industry is not cleaning up, then that, of course, that's legitimate.
I'm going to suggest you get called as to be deposed on this point when it comes up in litigation.
Well, I mean,
I'm glad to hear that.
What's an example that you know? I mean, you can talk in broad generalities, but is there an example of that would be that you think would be controversial?
I personally don't. Again, as long as it's a prospective fee.
I mean, Sinclair and its progeny were about you know, mitigating for past actions, which was I mean, I think it was a goofy decision, and they just sort of made it up. But I don't think that there's a lot of controversy over a fee if it's not used for revenue raising. Mm-hmm. If it's used for a legitimate regulatory program, then I don't think it's really that controversial.
Okay. That's good to hear. Kelly, do you disagree with that, or do you want to add?
I don't disagree with that. I do think, however, it's not necessary to establish as a separate fee, but it is a component of your overall cost to provide the service. Mm-hmm. For example, on the wastewater side, you have all sorts of regulatory requirements you have to comply with in order to meet the clean water standards, et cetera. And those are embedded in the cost of providing service. How you allocate those costs are often dependent upon the demands and the impacts that the individual customer class puts on the system. And that's how you allocate those costs. It's the same thing with regard to water, in my view, is that, you know, there are costs to developing water supply and management programs, to developing additional water resources, to developing a conservation program, and all of those costs can be allocated both on a customer class basis and on a tiered basis, because you're looking at the individuals who place the most demands on the system and therefore generate the costs. That's a simple concept to me in terms of applying Proposition 218 to rate structure design.
You know, and if I could just jump in there, when you're talking about the infirmities of 218 and 26, you know, I think you just get distracted when you're talking about molecular accounting and tiered rates. I mean, those are, those are infirmities frankly, in the judicial system, with the lack of imagination or expertise by a judge. I mean, if you want examples of that kind of infirmity, let me introduce you to CEQA.
But my guess is a few people in the audience are familiar with CEQA.
If there is a system, if there's a systematic problem with that, then maybe you need to change the Constitution. But I think that's the tail wagging an elephant there. Where you have I think the more interesting question is, has to do with flood control and stormwater. And just to put my bid out there, stormwater is and the last panel talked about this. Stormwater is a general is a general issue that is of general concern to the region and to the state. And there are really two aspects to that I think take it way outside the Prop 218 world. One is that the difference between stormwater today and stormwater 20 years ago is that it's become a matter of regulation, both federally and the state, where it's no longer a matter of making sure the streets don't flood. It's a matter of making sure that pollutants don't enter into the ocean and the trash and everything else. So it's become a matter, the new stormwater requirements are a matter of state regulation as opposed to just the function of moving the water off the road. So that's one aspect. The other aspect is what I was saying. It's not something you can attribute necessarily to a particular water user. It's not a water user. It's a water, whatever the opposite of it is, a water get it off my property
Yeah.
person. And so both of these things, to me, it leads to a couple of things. One is that it's, as far as providing facilities, it's perfectly appropriate to do geo bonds for that sort of thing. Secondly, it's perfectly appropriate, and I would think it would be required for the state of California to play a much larger role in paying for stormwater mitigation. The state water board has certainly played a big enough role in raising the stakes and raising the cost of dealing with this. I think the state of California should play a bigger role in paying for it, whether it's through geo bonds, whether it's, somebody mentioned the role that streets and highways play on stormwater. It's an extremely big role, and we have a big transportation funding shortfall in California. That has to be addressed. The legislature needs to address the state of our roads and highways and bridges, both state and local. Well, at the same time, they could use a piece of that to pay for some of the mitigation of the stormwater in states' roads and highways and local roads. There are lots of opportunities there, but I think that putting together stormwater and Prop 218 is a distraction, and it takes away from actually solving the problem by trying to fit stormwater into the 218.
I do want to reserve a little time for questions, but let me just ask the panel very quickly, do any of you favor submitting to the voters an amendment of Proposition 218 to allow stormwater discharge charges to be enacted by simple majority vote of the governing board?
Uniformly, yes.
Yeah? Yeah? Okay.
I don't like supermajorities, period.
I'm
so
with, lest you're after my own heart, wherever you are.
Yeah. Okay. Well, let me turn it over for questions. Again, those who are watching live streaming on the internet, again, the Twitter hashtag is pay4, that's numeral 4, water. Those of you who are too shy to raise your hand, you can also tweet your question in, and Katrin will read it. So I'll just open it up for questions at this point. This either means everybody's hungry, or we have time to ask one last. I have time to ask one last question of the panel. Are there anything from Twitter? Oh, we have one question over here.
I really appreciate the discussion. I'm Jeff Brasso. I'm the executive director for the California Stormwater Quality Association. This may be a really simple question or a really hard question. I'm wondering if anybody, maybe even in the room, knows why stormwater and flood control were not given exemptions under Prop 218. It seems, in looking back, it's kind of strange that they weren't. Is it because the thought was that they would be handled as a public benefit in a general obligation way, or was there something else behind it?
I have a theory, but I'm going to defer to the people who actually were working on this at the time it was drafted and passed.
I have a theory, but
Well, let's start with theories then.
my theory, I think they just didn't think about it, honestly. Stormwater wasn't as big of an issue in 1996, and I think that it has become an issue, and as a result, you know, it was like an afterthought, ooh, maybe we should have included that as well, but that's just my guess.
My theory is very similar to that. My theory is that Proposition 218 fundamentally deals with service to property. And so when they made exemptions from the voter approval requirements for water and sewage charges, again, those are services that are provided to property, whereas as Lauren just said, with stormwater, it's really the opposite of service to any individual piece of property. It is, I think, classically, in my view, it's a regulatory fee. So I think, again, they just really weren't thinking of it. And I personally don't think it fits very well within the Prop 218 rubric as a result of that.
I don't think it fits very well inside a regulatory fee. I mean, for industrial discharges, they're subject to permits and regulation, and they're held to a very high standard when it comes to stormwater discharges. But otherwise, it's not. You're not regulating a homeowner on. You're not regulating a strip mall, except to a slight extent. You know, it is a general governmental function.
And while I think it fits within the rubric of a regulatory fee, I agree with what Bobby said last panel, which is that we ought to regulate and control the amount of pollution discharge rather than charge a fee for it. But again, I think this has applicability also to groundwater pumping charges and groundwater augmentation programs where you might use a fee to create incentives or disincentives to use or for conservation as well. So it's very much a broader topic. That's the best we can do anyways in answering that. Other questions? Yeah, yes.
How do you feel about water courts or some semblance of water courts in California?
It's an intriguing idea. Right now, there is a group called Dividing the Waters that, Brian, I think you participate in, and it's basically attempting to fill a gap, or maybe it's more of a, it's an educational program which is designed to have judges and experts educate judges, other judges around the country about water cases. So it's not a water court, but it is high-level specialized training for judges. Now the problem is there's no assignment mechanism in any superior court that I'm aware of that says, oh, the water case goes to Judge X. So it's kind of hit or miss whether a given judge is actually going to have been trained by Dividing the Waters. I think there's a lot of administrative problems with a water court. Perhaps at the appellate level, it might make more sense. But so many water disputes have a very specific local connection, and I'd really hate to lose that. And unless you want to go to the Colorado model, in which the entire judicial system sits as a water court for at least a part of the year, then you're going to lose that local awareness and sensitivity.
Yeah, I agree with that. The only other thing I would add is if we did have a water court system, it wouldn't be at all clear to me that these types of cases would get there because Propositions 218 and 26 and 13 deal with all sorts of fees and rates and charges, and you'd want the courts would worry about consistency between the water court's interpretation of those statutes and then the general court's interpretations in other contexts. But again, I think it's an intriguing idea. Other questions? Well, we have 2 minutes, so I'm going to deprive you of lunch for just a moment. We have Twitter? Anything on Twitter?
Yeah, Twitter. And now I just, okay. So the question is how access to data and higher quality data play a part in addressing these challenges.
Sean or Kelly?
Concerning rate structure design? Okay.
Well, it's definitely important, obviously. I think the hard part and the piece that a lot of customers miss as you go through the rate setting process is why you're designing the rate the way you are and what you're trying to accomplish with that rate. Because ultimately that rate structure should really reflect the utility's goals and objectives. Are we trying to gain conservation? Are we trying to promote selling water? I mean, we all want to sell water from a utility. It gives us more revenue. So what are those goals and objectives, and what are you trying to meet with that? Are you trying to maintain revenue stability? So the better the data, definitely the better the quality analysis you're going to do, as with anything that you're trying to accomplish. But that is a big part of it. The other piece of it is, over the last 10 years, 5-10 years, we've been developing rates without that data because people weren't metered on the water side. And so that was always a challenge, guessing how good you are at estimating people's consumption. So obviously as you get meter data, things get better, and you can do that both on the water and wastewater side as well.
At least, however, we have 2 recent court cases saying essentially that the data does not have to be precise. But you do have to have sufficient data to demonstrate the basis upon which you're developing your rates.
Well, it's now 1 o'clock, so I lost my 2 minutes. The question I was going to ask the panel was, is it desirable to amend these propositions, these provisions of the Constitution, in a way to address some of the big issues or some of the judicial misinterpretation, smaller issues? Unless anybody can give me an answer in 10 seconds to that, I think I'll just leave that for discussion perhaps over lunch. But anyways, let me just say thank you to the panel. I think Ellen has a couple of concluding remarks, but thank you all very much.
I want to thank